we can't go back and talk to Mr. Barbie. I'm sure Miss Osborne or whomever will say it was his intention that Miss Barbie gets nothing.
The record, this matter is before the court. The account of a motion filed by the estate of Anthony Barbie, the defendant herein, who's now deceased, and a motion to show cause against the plaintiff relative to disposition of a 401k in which Mr. Barbie, who's now deceased, was a participant. Mr. Barbie was the beneficiary of that 401k, which was never changed subsequent to the judgment of divorce. In any event, this hearing is being conducted via Zoom this morning. Present is Attorney Sandrato, representing the estate of Anthony Barbie. It's like Gina Osborne is present. I believe she's the personal representative of the estate. Is that correct, Mr. Sandrato?
That's correct, Your Honor.
All right, good morning. In addition, Attorney Nicholas Darren is present, representing the plaintiff, former spouse Linda Barbie, and Miss Barbie appears to be present. Good morning, everyone.
Morning, Your Honor.
Morning, Your Honor.
Court has reviewed the pleadings. Court has also read the case of the Reed Estate versus Reed, 293 Mishap 168, 2011 Court of Appeals case, which is most relevant, and both parties have addressed and cited that case in their respective briefs. So there's no need to recite what or has already been stated in your briefs, but I'll give the parties just perhaps a short period of time to anything additional. And Mr. Sandrato, do you want to begin?
Thank you. Thank you very much, Your Honor. From the perspective of Ms. Osborne, this is a purely legal matter to be decided by the court. We believe that Reed v. Reed, a reported course from the case from the Court of Appeals, is the controlling authority here. We believe that there are no factual distinctions of any material sense with respect to the consent judgment that was, or excuse me, with respect to the judgment of divorce that was at issue in Reed compared to the judgment that was at issue here. Both of those are similar in the sense that both judgments provide for the disposition of qualified IRAs, including a 401k that were to be retained by in both cases, a decedent who passed away after the judgment of divorce, but prior to the execution of a change of a beneficiary designation for the 401k. And under those circumstances, that the claim that although the beneficiary designation may control for purposes of the initial disposition of the money from the custodian of the 401k account, the ex-spouse in both cases, by virtue of relinquishing any claims to those 401ks in the context of the consent judgment of divorce, has relinquished those claims. And that there is no facts before the court that would permit a finding that there is any type of there are no facts alleged before the court that there is any suggestion that there should be a disposition otherwise. I would point out that with respect to the brief that was submitted by Mr. Darren, he points out, he makes argumentation regarding his position that there is no waiver as such in connection with the consent judgment that is at issue here, and that there was an express waiver in Reed, and that is the distinguishing factor between the two cases. I don't believe that's an accurate recitation of the Reed case. I mean, in both cases, there is a disposition of the 401k, identifies to whom the 401k is to be disposed. And then there is a statutory insurance provision common in Michigan judgment entries that pertain to insurance contracts, annuities, and endowments that may be subject to 401ks. But the fact of the matter is the waiver that's at issue, it doesn't say, quote, I waived claims to the 401k benefits. What it is the relinquishment of the right to the 401k beneficiary that is agreed to in connection with the consent judgment. That, I believe, is the express waiver that the court in Reed was referring to. It's not referring specifically to the insurance language in the statutory insurance language that we see on page 171 of Reed. So it is, and of course, it is the requirement and legal duty of the personal representative to marshal assets for the benefit of the estate to be distributed in accordance with the estate. In this case, it's an intestate estate, but in accordance with the statute of descent and distribution.
Thank you. Mr. Darren, response?
Yes, Your Honor. I mean, I do believe that the Reed case is distinguished from ours in this case. While Mr. Sandrato was pointing to the statutory waiver, that there is additional waiver language that's in Reed that's not in this case. It states specifically, it shall be the responsibility of each party to make the appropriate changes in beneficiary designation. And it goes on for another run-on sentence there about that. That's not in the Barbie judgment. These parties got divorced. That property was awarded to him. There's not really much dispute to that. But we want to look to facts. He had all that time to change the beneficiary. He was advised by counsel. He had counsel at the divorce that he would have had to do that. Unfortunately, we can't speak to Mr. Barbie or what his intentions were. So that's what the beneficiaries are for. He left Miss Barbie as a beneficiary for a reason. If you want to say, oh, he forgot and now this is a fail-safe, like we can't go back and talk to Mr. Barbie. I'm sure Miss Osborne or whomever will say it was his intention that Miss Barbie gets nothing. But he had time. Changing a beneficiary, as the court knows, is not a difficult process. It's one phone call and a piece of paper, and the beneficiary gets changed. He didn't do that in this case. The property was awarded to him. He did with it what he wanted. He left her as the beneficiary. I mean, the Reed case is distinguishable because there's implicit and explicit waivers in that judgment. Those aren't in here. There's no waivers or instructions for what people are supposed to do. It's just, hey, it's yours, and it's kind of do with it what you want. He did with it what he wanted. He left Miss Barbie on there. I understand, and the one thing too, like is not mentioned, is it's not that this is the only asset of Mr. Barbie. He didn't disinherit his entire family in exchange for Miss Barbie. The estate has been funded by other mechanisms and other things that were given. He made other people beneficiaries on other accounts. So this isn't the only account, and it slipped his mind to change her. There's other accounts, there's other stuff out there that went into this estate. So, Your Honor, I think the Reed case is clearly distinguishable because of especially the way the court treats it and kind of goes to these waivers. And then on top of that, he was in control of this account and he made his decision to leave the beneficiary. That's what we look to. That's why the beneficiaries are there. If we just were going to ignore the beneficiaries on this, and we'd be in court on every estate because, oh, he didn't mean to leave it to this person. Like, that's what the beneficiaries are for. He had the ability to change it. He didn't. I think the money should be left with Miss Barbie, and Fidelity contacted her the same as they would as the fiduciary for Mr. Barbie, fulfilling his wishes of giving the money to the beneficiary.
Court notes, Mr. Darren, you represented Miss Barbie in the divorce. As Miss Barbie being the plaintiff, did you prepare the judgment?
I did.
All right. Did Mr. Barbie update the designation beneficiary subsequent to entry of the judgment of divorce?
Your Honor, I didn't represent Mr. Barbie. I wouldn't know. He was represented by Miss Roca at the time.
Has anyone been in touch with the plan administrator? Is there any indication that Mr. Barbie changed his position and updated renewed the designated beneficiary as Linda Barbie subsequent to entry of the judgment?
I don't know, Your Honor, and I don't know if that would really be relevant. I mean, I understand.
Well, it would be relevant as to the intent of the parties. There's a suggestion that they reconciled, and that was Mr. Barbie's intent. But the court is of the opinion that the Reed case is right on point. The issue for this court was the waiver by the designated beneficiary, Linda Barbie, was it clear, unequivocal, explicit, voluntary, good faith, consent judgment divorce? And the court determines, yes, it was. She gave up her right to that 401k. It's clear under the terms of the judgment. Counsel for plaintiff prepared the judgment. Perhaps if the defendant would have prepared the judgment, it would have been a little clearer in terms of explicit language. There is a waiver, the standard insurance provision waivers. But notwithstanding that, the court finds that the Reed point is on point and that the proceeds of 401k should be paid to the estate of Anthony Barbie. Has the administrator paid out any proceeds yet to Linda Barbie?
Yeah, this was over a year ago, Your Honor. He died. The proceeds were paid and have been already transferred into a separate account.
court will order that Linda Barbie return those funds, 100% of those funds to the estate of Anthony Barbie. I don't know if those are still preserved, but again, if the court will order that, if to the extent that Ms. Barbie sells those funds, that those shall not be expended.
Your Honor, I
I
don't
don't know.
think the return is just that easy. If the money has been placed into qualified funds, there's penalties and tax things. That's not my client's fault that Fidelity gave her the money. So she's got to eat thousands. I mean, if we're talking about 150 grand, she's got to eat thousands in penalties and things like that because of Fidelity's mistake
Okay.
or Fidelity's
Perhaps,
actions that are
and
consistent with the statute.
there's no mistake on the part of Fidelity. The court will acknowledge that. I think Fidelity is duty bound to pay those proceeds to the designated beneficiary Linda Barbie, but notwithstanding that, the estate of Anthony Barbie is entitled to those funds. I don't know what to suggest to counsel, but obviously, yeah, that's a valid point, Mr. Darren. Obviously, Ms. Barbie shouldn't have to incur penalties or taxes. So I'm not sure, perhaps counsel between the two of you can figure that out and determine the appropriate amount to be paid so that Mr. Barbie is not saddled with any penalties.
I will confer.
Tax consequences.
I'll be certain to, I will confer with Mr. Darren on that issue.
And if necessary, you can come back before this court, but it is the order of this court that the estate of Anthony Barbie is entitled to the 100% of the proceeds from the 401k. It's unfortunate that was not brought before the court previously, but even if it was and they not pay out the proceeds, I believe that Fidelity is duty bound to pay those proceeds pursuant to ERISA to the designated beneficiary, which is Linda Barbie. But after that, the state court has the authority to address that issue, and the court again believes that the Reed case is on point. So court will enter an order. Mr. Sandrato, you prepare the order that the proceeds of 401k be payable to the estate of Anthony Barbie forthwith. And yes, if in fact that you need to address those tax consequences, it's a valid point. If counsel cannot work through that with the assistance of an accountant, a financial advisor, then you can come back before this court.
Thank you, Your Honor.
Okay. Thank you very much, Your Honor.
Sandrato, you'll prepare the order.
Yes, Your Honor.
Anything further, Mr. Darren? I'm sorry.
No.
All right, that will conclude this matter. Everyone can zoom out. Have a good rest of the day.